Mr. Licciardi?
Thank you. Good morning, Vincent Ricciardi, representing Mr. Carlos Valerio. We're here today presented with two questions of law reported by Judge Chernoff of the Superior Court Department. Questions evolved from this set of facts. Back in September of 2003, a detective from the Hudson Police Department made an application for a search warrant with regards to the property at 165 Main Street, Apartment 11 in Hudson, Massachusetts. The affidavit was accompanied by the application itself. And in the application, in the location where the officer should have placed the items to be seized, he erroneously placed the address to be searched. Not only on the application did he do so, but also on the search warrant that issued out of the Marlborough District Court. There was absolutely nothing on the warrant or the application itself to indicate to anyone what the officers were to search for. The officer, along with other members of the Hudson Detective Bureau and Police Department, joined prior to executing the warrant, and as a part of the evidence-gathering kit, they included the warrant and the affidavit, which was attached by a paper clip. This is what Judge Chernoff found. That was placed in a Rubbermaid container along with other implements used during the search and was brought to the location.
Now, the affidavit indicated what things they were looking for, right?
No question about that, Judge. No question. When they arrived in the vicinity of 165 Main Street, they took up position, and they saw the defendant along with his brother arrive shortly thereafter.
The purpose of the requirement of having the warrant and the affidavit present is to show the person in charge of the premises what they can search for, and so the police will know what they're searching for. Is that right?
That's correct.
Okay. If the affidavit were in the Rubbermaid container, as the facts are here, aren't those two purposes served? It's there if the person wants to see it, and it's there if the police need a guide. Why does it make a difference if it's in the police officer's pocket or if it's in the Rubbermaid box?
Two things, Judge, respectfully. First of all, I would suggest that the facts of this case, the affidavit was not incorporated into the search warrant to satisfy flourish and grow. The incorporating language used in the search warrant solely related to the issuing magistrate reviewing the affidavit and finding probable cause to search for what's listed below, and there's nothing listed below. So the incorporating language was insufficient in the present warrant. Additionally, having the affidavit present in a sealed container and not making the defendant aware of its presence.
It wasn't sealed so that it couldn't be opened in any way.
It wasn't made. The defendant was never made aware that that affidavit was present. It was never made aware by either the show of the warrant itself what they were there to search for.
Well, he didn't ask to see it, did he?
It was never presented.
Well, he didn't ask either.
Is there a rule that it has to be, that the affidavit has to be presented?
I would suggest that the warrant as well as the affidavit should be presented. I would suggest in this Commonwealth that the warrant itself in accompanying document that may list the items to be seized should be present and shown to the defendant upon request, or at least shown to the defendant prior to the commencement of the search.
Okay, but it was present, and there was no request for it to be seen.
But it was never made available to the defendant. I'm
You
suggesting...
just changed what you said would be the rule. You said you would suggest a rule that it be present and made available to the defendant upon request.
And made available to the defendant. If I said at request, I stand in error. It should be shown to the defendant. He has a right to know that these police officers went before an issuing magistrate, some judicial authority, and they have judicial authority to be there to search for particular items. And that was not done here.
Could you clarify for me now? At one point, he's put on the floor, as I understand it.
Correct, Judge. He was actually apprehended in a common hallway outside of apartment number 11, somewhere in this apartment complex. He was taken down by the police officers. He was cuffed.
He's cuffed.
And then
he's on the floor.
And then they ram his door down to that apartment, and they bring him into the apartment.
And at that point, they show him a piece of paper.
They show him a piece of paper. According to the officer's testimony, it's the front page of the warrant. Again, that page lacking the items to be searched for. There was no evidence, no evidence that he read it or that he questioned it. He's cuffed in a chair in his kitchen, and he's shown a document.
Well, what are you saying? Are you saying that in every case, a person should have a chance to sit and read the document. They can't be cuffed. They can't be on the floor. They have to have an opportunity to read it and study it.
I'm not saying that, Judge. What I'm saying is they should be shown a warrant that indicates that the police have a right to be in that particular location and to search for the particular items listed on the warrant. I suggest that the Gauthier case that this Court decided a number of years ago states that the intent of the warrant requirement is to notify the individual of the police officer's authority to be on the premises, and further, that the police officers have authority to search for particular items, and the way to notify is to show them the document.
What's the Supreme Court case say?
In Groh?
Yeah.
Groh says that that was decided on a Fourth Amendment basis, and that the officers had were required to show the defendant a document, the search warrant, indicating exactly what I've just stated, those two items, the items to be searched for and their authority to be on the premises to be searched. And that they also carved out the exception that if there's an additional document, it may be incorporated by specific reference to that document with regard to the items to be seized, unlike this case.
So if the warrant had said, see attached affidavit,
I would suggest that the warrant should have said narcotics, see the attached list of narcotics that we're looking for.
Right. So, I mean, there's no question this warrant was an error. I mean, this is a screw up on the face of the warrant. The question is whether that's fatal. The affidavit is incorporated by reference.
I would suggest, Judge, that it wasn't incorporated for purposes of identifying the items to be seized, only for the purpose of the
It just says the affidavit, which is hereby incorporated by reference, has been made, and I find there's probable cause to believe, and then it goes on and on and on.
Well, the on and on is the important part, Judge.
Well,
on to seize
it has
the
probable
items,
cause
the items, and it's not there.
But, yeah, well, that's because you're saying if this were done correctly, it would be okay. But it's not done correctly. We all acknowledge that. The question is whether it's constitutionally defective.
And that's what Judge Chernoff is asking you to decide. I'm saying that the answer to both questions presented by Judge Chernoff should be answered in the affirmative. They should be answered yes, that this warrant, because of its lack of identifying the items and a lack of any document being incorporated specifically by reference,
well,
is fatal.
The items are identified in the affidavit quite clearly. This is a search for drugs. There's nothing exotic that's being searched for here. It's pretty straightforward. It's all in the affidavit, exactly what they want to look for, the basis upon which they want to look. The magistrate clearly received all of this together, stamped every one of the documents, found that the affidavit provided probable cause to believe that items were, that there was probable cause to believe that there were items there that could be searched for, that they were there and that they were evidence of a crime, and the place to be searched. Why do you need more than that for constitutional purposes?
The next step, Judge, is notifying the defendant, and that wasn't done.
Well,
I would suggest that, again, Gauthier, Grove, Forrest all require
well, then my question is to you, what does the court require? The court requires that it all be there, right? That if there's an attachment that's relevant, it has to be there.
Correct. The warrant has to be there, according to...
And if the affidavit is necessary to the warrant, or some other document is necessary to the warrant, it has to be there, too.
If it's incorporated properly, it should be there.
What was the purpose of them showing him the piece of paper?
I don't know what was in the officer's mind, Judge. I would suggest that he was attempting to show him something that gave him legal authority to be there to search for particular items.
Of course, we can maybe limit this case if we rule for the Commonwealth by saying the affidavit was actually in the premises. They brought the Rubbermaid container inside the apartment, did they not? Which had the tote in which the documents were. I mean, if they left it off in the police cruiser outside, that might be a little bit more of a problem.
My
I'm
question
just
is,
theorizing now.
What difference does it make if it wasn't made available to the defendant, whether it was in the Rubbermaid container, the cruiser, or left back at the police station?
Well, if the defendant had read the warrant and said, "Hey, it refers to an affidavit here. I don't see an affidavit. Where's the affidavit?" They could have provided the affidavit, right? Immediately.
Again, if that could have happened, but it didn't.
But isn't that all that need to have happened, doesn't it?
I would
Go ahead.
suggest the courts indicate again that the items should be shown on the warrant or specifically incorporated by a document attached to the warrant.
But
And that wasn't
there's no
presented
case
here.
that flat out says, is there, that you have to show it to the defendant, both documents?
Flat
That's
out,
why we're
Judge.
here. That's why we're here, aren't we?
Flat out, Judge, I would say yes.
There is a case?
I would say your case, Commonwealth versus Gothia, states that the warrant procedure, okay, the intent is to notify the person that the officers have been authorized to be in that particular place to search for that particular thing. How else do you do it unless you show them the warrant?
Well, that doesn't flat out say it, but,
Well, it
you know, I know.
comes as
It's-
close
it's
as
coming,
this court has
it's
said.
inching
And I would suggest that
around.
you take that next leap and say that, indeed, they must. They must show the warrant to the individual, indicating that they have judicial authority to be there to search for those items.
All right,
Thank you.
thank you.
Thank you, Mr. Licciardi.
Thank you, Judge.
Mr. Gentile?
And your position is they don't have to show it to them. They should, in an ideal world, show it to them. That's the best practice, but this makes it over the doorway.
Yes, Your Honor,
of
that's correct.
Constitutional appropriateness.
That's correct, Your Honor. My name is
And you
Joseph-
don't have a case flat out either that says doing this kind of thing is all right.
There's no affirmative case that declares that they need not show it to the person at the residence. However, there's,
Yeah.
But
And
isn't that what's behind the reason for the particularity?
the cases, Your Honor, discuss the notion of particularity to prevent a general search, which was certainly done here. At the time of the issuance and at the execution, the prevention of a general search is accomplished by the attachment of the affidavit to the warrant with incorporating language.
But this is so sloppy. I mean, what defendant, in circumstances like this guy was actually handcuffed, I think, at the point they got around to doing the search, wasn't he?
Yes, he was, Your Honor.
Well, even if he wasn't, what defendant is going to be smart enough to say, look, I want to see the affidavit and the warrant so I can, you know, make sure everything is appropriate here? I mean, who's going to do that? So why don't they do it right?
Your Honor, I would suggest that this officer certainly wishes that he had done it right. It was a human error of a technical nature, of a clerical nature at the
It's
time.
not a technical nature or clerical nature. If you read Glow, never mind us, this is the United States Supreme Court talking in 2004. I mean, it seems to me that it's absolutely implicit in that what they are saying is you can incorporate by reference, but they're not saying you can incorporate by reference and then leave what you've incorporated back at the police station.
Well, it's not back at
That's
the police
correct.
station
In
here.
this-
It's in the apartment.
I know it's in the apartment. You can't leave it back at the police station, right?
That's correct.
Implicit in that is that you're showing it to the defendant.
I
Or
don't
making
believe
it
that's
available.
implicit. It's available if the defendant requests it.
Well,
or
the
if
question
it's
is, how much of a
request.
burden are we putting on the defendant? I mean, there's no evidence here the defendant even read what was shown to him, is that right?
Shouldn't
That's
have
correct.
it.
He was
He
or-
shouldn't have any burden, should he? What burden? Why should he have a burden? It's up to the Commonwealth to do the search, prepare for the search properly.
I'd suggest that this officer did take every step along the way to prepare for the search,
Can I
to
just
prepare
read,
properly.
can I just read to you from the United States Supreme Court? It says, indeed, have held, talking about, we don't say that you can't incorporate cross-reference, have held that a court may construe a warrant with references to the supporting application or affidavit if the warrant uses appropriate words of incorporation and if the supporting document accompanies the warrant. Now, one way to read that is it accompanies because there's a police officer standing outside that's got it in his back pocket. I don't think that's a fair reading of what the United States Supreme Court has said. Accompany the warrant clearly means with the warrant.
Your Honor, one distinguishing aspect of Grow is that in that case, in the Supreme Court case, there was not incorporating language on the face of the warrant. There was not language which incorporated any way. In this case, there is such language.
But it has a two-part. Now, admittedly, in Grow, it was under seal, the accompanying affidavit. But it seemed to me that if you say accompanying the warrant, there's no suggestion that the defendant, a defendant in Grow could have asked to see the, where's the particularity?
Your Honor, I think that the issue in Grow, it speaks specifically about attachment and issuance, and then attachment or availability at the premises. And in this case, again, that was met where
No,
the
accompanies the wallet.
accompanies to the scene. And in this case, again, as
It doesn't
pointed
say
out,
that.
I interpret that the accompanies language means that it accompanies, it's available there for inspection if that situation requires it. I don't believe that Grow is mandating that the documents be shown to the particular individual. I'd suggest to this Court that requiring such a rule would be overly burdensome on police in the performance of the execution of warrants, that it requires basically an identification or, in fact, a location of a person to whom to show the document. In certain situations, the individual is not always at the location at the time. And in certain situations, in fact, in this case, Your Honors, I'd suggest that but for the fortuitous circumstance that the police, in fact, allowed this defendant to remain at the scene, they certainly would have had every right in this case to have arrested him, removed him from the scene as an individual under arrest, brought him back to the station, and then proceeded to execute the search warrant in question. By keeping him at the scene, they in fact enabled the defendant to be present. They orally notified him of this, that the search was for drugs. At the time he showed the single page, the officer said, "We're here to search for drugs." And the defendant, in fact, acknowledged that by indicating, when asked the question, "Are we going to find drugs?" He indicated where they would be, and he brought the officers to that location in the bedroom to show them where they would find drugs.
So assume we agree with you, then the rule from the case is that in the future, when they execute a search warrant, a defendant has to say, "May I see the affidavit?" You put the burden on the defendant to ask to see it. Defendant's supposed to know that.
It will only arise, Your Honors, in the situation where the warrant itself, for some reason, doesn't have the information on its face. But if it doesn't have it on its face, and the information is there and present and available, then the individual would have to request it in order to see it. That's the state of the law, I would suggest to the Court.
Well, what about this
time.
Grow case that the Chief Justice referred to?
Yes, Your Honor. I don't believe that case is requiring that the requirements laid out in that case are met in the facts before you in this case. The requirements under Grow are that it either be on the face of the warrant or it be incorporated by reference and present and available at the scene, accompanying the warrant to the scene. In Grow, it was not.
Would that be satisfied if, let's say, there was an officer, we're in an apartment building, and you've got a police officer at the first floor of a building, and you go up to the fourth floor, and you, without the affidavit, and you search? Would that satisfy it?
I would suggest it would, Your Honor, that it's available at the location if it's requested to be reviewed.
Aren't you, and it seems to me that you're asking us to save this case and to carve out an exception that really the law has not made room for, and a dangerous exception in a way, because as Justice Allen was just suggesting, you can keep moving it further and further away just to save this case.
No, Your Honor, I'm not asking the Court to expand the rule. The discussion in the Forrest case in this State and the discussion in Grow both outline the scenarios. There's been a long line of cases which have indicated that requisite particularity or information, for instance, about the location to be seized can be supplied if they are absent in the warrant's face itself. So those lines of cases all contemplate a scenario where that can occur. In Forrest and in Grow, the problem was that the requirements that need to be met in order to accomplish the supplementing of the warrant were not met on those facts. Here in these facts, that was in fact accomplished. Under the Forrest analysis, the attachment at issuance, as the Court has pointed out already, it was reviewed by the magistrate, each and every page stamped, and the requirement that it be present at execution, those were both met. And in Forrest they were not, nor in Grow were they met, because the incorporating language was absent from the face. So I'm not asking this Court to expand upon or create a rule that is going to create problematic exceptions. In this case, Your Honor, to do so would be to essentially punish the officer who in many respects took many steps along the way to do things correctly. He did prepare, he informed other officers, he had the operational plan meeting, he had a written document of an operational plan, which is part of the record. He took all the steps so that this was not a rush to execute, this was not a situation where the officers were intentionally in any way performing or committing any type of misconduct. So to rule that it was, to somehow exclude the evidence or to rule in favor of the defendant in this situation, there'd be no prophylactic effect on officers. The officer here took all the steps correctly, but because the language of the face of the warrant is incorporating the affidavit, the warrant can certainly be saved on this situation.
So you're saying that the police have no obligation at all to tell the defendant that they have a warrant?
They may be required to tell them that they have a warrant.
And that's all? They don't have to show him, there's no obligation to show him the warrant?
That's correct. It's certainly in a perfect
But
world.
I'm sorry, go ahead.
I'm sorry. In a perfect world, it is the best practice, and I believe in most cases it is, in fact, done. But there are many scenarios not in line with the facts of this case in which officer safety, the practicality or their ability to execute warrants safely and efficiently are implicated by imposing such a requirement. So there is no such
But isn't one of the reasons for having a warrant to show a defendant the warrant, to show the defendant the scope of the police authority so that the defendant, or whoever's house it is, can assist the police and say, hey, look, if this is what you're looking for, I'll take you right to it, so you don't have to kick the door down like they did in this case and destroy property?
Well, Your Honor, it may be part of that. However, the officers certainly should not be limited by what an individual who is shown a warrant tells them they can find. For example, if they are able to locate certain items at the direction of the defendant, it shouldn't limit their ability to go beyond that and execute the warrant more fully or more thoroughly. Otherwise, it would put the defendant in the position of essentially being able to control or to manipulate what the police were able to do.
No, what the Supreme Court has said, that one of the purposes of a particularity requirement is that it assures the individual whose property is being searched that there are limits on the power to search. If you don't attach it to the warrant, if you don't show it, how does the individual know what the limits are, if that is one of the purposes of the particularity requirement?
It is one of the requirements, Your Honor, but I'd suggest that here it is attached and it is present, and that...
It's not attached.
Well, it is on the scene attached to the warrant in the Rubbermaid container.
Stapled or
It is paper-clipped. It's paper-clipped at the time at its location.
When he was shown the warrant, are you saying he was shown two pieces of paper?
No, Your Honor. The testimony is he was shown a single piece of paper.
Well, then it wasn't attached, was it?
It was not attached to the item of paper which was shown to that particular defendant.
Well, then how does he know what the limits of the power of the police officer are?
Your Honor, I suggest that the purpose of showing the warrant is to validate that the officers are present and have a purpose in their search. But there's certainly many of the cases...
I know that's your view. That's not what the United States Supreme Court has said is the purpose of the particularity requirement. I mean, I'm not making up the language. I'm just reading it.
Certainly, Your Honor. I would suggest that the cases, the federal cases, the implication of those cases is not that there must be a discussion or a debate or an explanation of any particular individual as to the scope of the warrant. It certainly, some of the cases talk about making sure that you don't create a situation in which people can contest with an executing officer what their scope or what their authority might be. The cases discuss that the purpose is not to have an extensive discussion with an individual on scene. The police should be enabled or able to execute the warrant in the manner in which they properly and safely believe that can be done. It shouldn't enable an individual to contest at the location. The contesting of the warrant is done after the fact.
Well, no, why shouldn't he be able to contest? I mean, if the warrant is for something that is, let's say, as big as this pitcher of water, and then the police start looking into drawers that are so small they couldn't possibly contain this pitcher of water, shouldn't the person be able to say to the police, hey, that warrant doesn't authorize you to look in those drawers, to contest it at the scene?
They may be able to do that, but certainly that would require an analysis afterwards by an individual or in the position of a judge to make that determination. It shouldn't engender any type of animosity between the police and the individual.
Nobody's talking about animosity.
Well, I'd suggest that it could create a situation where there's
If
contesting.
your position is correct, then why do the police officers have to even show a search warrant?
They may not in Massachusetts, Your Honor. They may not have to show the individual the warrant. They may have to say that we have a search warrant, we're
And
here to
you rely
search.
on what for that?
That there's no affirmative rule, certainly, there's no affirmative statute. Chapter 276, Section 2 and otherwhere does not make that requirement, whereas other states certainly, in some
You
scenarios, do
say
have
there's
rules.
a lot of times they do searches and the person isn't even there,
That's correct, Your Honor. And in fact,
or he's been arrested and taken away.
that's correct. There's also the issue that the police may have to, that there's no, it's not necessarily true that the person who's shown a document would be able to read it due to language, due to the fact that they may not be able to read the document itself. And it creates a situation, even in terms of identifying that individual. There's scenarios where there's people on scene, but their actual identity has not been firmly established yet. So you may be showing a warrant to someone who's not even properly in a position of standing to challenge it, to challenge the situation and what can be searched for. And it may, in fact, be revealing information to such a person, which could then be translated to others who would either take steps to destroy evidence.
As I remember, this is a no-knock warrant, so literally the police could simply have entered, as they did, well, here there was somebody present, could have entered without him being present.
That's correct,
Conducted
Your
the search.
That's correct, Your Honor. It was a no-knock warrant. It was authorized as such.
Was the defendant arrested at the scene before they entered, or was he seized under the authority of the warrant?
He was seized, brought to the ground, handcuffed, brought inside, sat down in a chair in the kitchen. He was given Miranda at that time.
Yeah, but under what authority was he seized? Was it under the authority of the warrant, or had he been formally placed under arrest?
The record does not indicate that he was formally placed under arrest or that the statement "you are under arrest" was made to him. I'd suggest that the circumstances factually would indicate that he was effectively under arrest at the time. In fact, they did give him Miranda before they asked him any questions, even so much as, "We're here for drugs, where would they be found?" So he was under arrest and certainly could have been, had they found nothing in the course of the search, could certainly have been arrested based on the information in the affidavit.
Thank you, Mr. Gentile.
Thank you very much, Your Honors.